Be totally ignored.
Yeah, so we have filed a petition for Supreme Court review of the Tennessee Supreme Court. It's raised issues with the opinion of the Court of Criminal Appeals. It is, as you all probably don't know, but as most lawyers working in this field know, it is incredibly rare for someone to win a post-judgment motion to get a case overturned by a trial court for ineffective assistance or for other reasons, like this case was. And so when the Court of Appeals reversed it, that was also, again, an unusual circumstance. It doesn't happen a lot. And so just because of how rare the circumstances of this case are, we're hopeful that the Tennessee Supreme Court will look at it seriously and consider that they need to be the ones to decide some of these issues. The really most important issue is how the attorneys at trial dealt with the issues around the identification testimony. There were some really questionable things that the attorneys did and things they should have done differently that they didn't do. And because of those things, the trial judge decided there had not been a fair trial. There needed to be a new trial. So Adam did not get a fair shake. We're hopeful that the Tennessee Supreme Court will at least want to decide that issue for themselves. The Court of Appeals just sort of, said, oh, no, it was fine. And in doing that, we raised a lot of things in our brief to point out the ways in which the Court of Appeals didn't understand the record, got the facts wrong. There's a couple places in the opinion where they're internally contradictory. At one point in the opinion, the Court of Appeals says, hey, this document, it's not in the record, we know nothing about it, so we can't rely upon it. And then in their same opinion, in a different footnote, it says, oh, it's right here.
And you're talking about the actual lineup.
The lineup, the picture of the lineup, Exhibit 25. And so that's the sort of mistake that when you make sort of basic mistakes like that, if I were a judge, I'd be concerned that, maybe you made other mistakes too. So we have briefed the petition and asked the Supreme Court to hear the case. They get to decide which cases they want to hear. And the state has said, oh, no, everything's fine with this case. It's not worth your time. Don't worry about it. And so now it's in front of the 5 justices of the Tennessee Supreme Court. If any 2 of them, I believe, maybe it's 3 of them, if any 2 of them believe the case is worthy of review, they will set it for briefing and argument, and then we'll have a whole set of arguments before the Supreme Court of Tennessee.
Okay. So 2 have to, okay.
So you've gotten is there a reply?
They've replied.
They replied, and they basically just
they just said, well, this case is not unusual from other cases, and there's nothing special about the standard, and the court got it right, and all these things they might have made mistakes about weren't really mistakes, and you can just turn it away like the rest of them.
Right. In the post-conviction relief, you were talking about that earlier. That it is pretty rare, isn't it?
It is very rare.
It's very rare. And I noticed we're noticing historically in Tennessee there was a problem when the Supreme Court came in and said you guys got to do a little better job here. In '61, so they put in post-conviction relief.
Yeah, and now there's sort of there's a recognized sort of due process right or a constitutional right to some sort of review after your direct appeals. If they didn't have it in state court, Adam could have gone directly to federal court and raised these issues there.
Right.
He can still do that at the end of this process if there's issues with it.
Right.
And hopefully we won't ever get that far because we hopefully get a new trial before then.
Yeah.
So
Okay, that's what
that work for you?
That works great.
Okay,
All right.
thank you.